The University of North Carolina at Chapel Hill in the national spotlight today and at the center of a landmark U.S. Supreme Court ruling. The High Court striking down affirmative action, saying that race-conscious admission policies at UNC Chapel Hill and Harvard violate the Constitution. New reaction has been pouring in all day. Speaking at the Essence Festival in New Orleans, Vice President Kamala Harris said she felt a deep disappointment in the actions of the High Court.
It is a complete misnomer to suggest this is about colorblind, when in fact, it is about being blind to history, being blind to data, being blind to empirical evidence about disparities, being blind to the strength that diversity brings to classrooms, to boardrooms.
Harris also called for urgency in making sure that all of our young people have an opportunity to thrive. Now, for some students, they say this ruling does exactly that, gives all students a chance to thrive. But other students feel this will have a huge implication on diversity in college classrooms. Take a listen.
I'm ecstatic about this decision. It means that Asian Americans can finally get treated on their merits.
It marks the promise of a new beginning, a resurgence of the principles of the American dream.
So let's look forward here. What does this mean for us moving forward? The short answer is we have no idea, but there is a longer answer. So let's go in depth for just a moment and start at UNC with Professor Andy Hessig.
What I do know is that obviously the admissions process is going to radically change. Even though the schools are no longer able to sort of seek, diversity for diversity's sake, they have lots of other questions that I think will lead to diversity.
So that's right. The justices, of course, didn't rule out race entirely in the process. For instance, Justice Roberts writing this: nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion on how race affected his or her life.
And an applicant could say, oh, I've experienced discrimination in life and I've overcome adversity. And that quality of overcoming adversity or being courageous or being inspired to work hard, something like that. All of those things are okay to consider.
So that means everyone in education right now is reimagining how a university can actively and intentionally be more diverse on campus without the use of affirmative action. President Biden said this earlier today about his plans dealing with the Department of Education.
Discrimination still exists in America. Discrimination still exists in America. Discrimination still exists in America. Today's decision does not change that. It's a simple fact. Today, I'm directing the Department of Education to analyze what practices help build a more inclusive and diverse student bodies and what practices hold that back.
So they are going to analyze data that is complex, of course. There are many factors at play, but it is clear that during the decades of affirmative action, our local schools increased diversity in their student bodies. This is student enrollment from UNC, Duke, and NC State, starting in 1980. The data shows that at that time, all three universities were overwhelmingly white. About 9 out of every 10 students on campus were white. But by the time this recent lawsuit was filed against UNC in 2014, the shift in the demographics, as you can see, up in 2021 even, changed dramatically. That said, you can't attribute that entirely to affirmative action. We know this by looking at states that banned affirmative action years ago, like California. They abandoned the practice back in the 90s. In fact, there are 9 states that have already had bans before this in place, and the impacts there have been difficult to assess. For instance, Michigan's ban passed in 2006. At the time, about 13% of the University of Michigan's undergrads were minorities. Fast forward a decade later, that number did drop to about 10.5%. But then another decade passed, and the number bounced back up to being over 13%. The university chalks that recovery up to new outreach programs and other race-neutral methods, but they can't attribute it to affirmative action because it wasn't in place. It's almost impossible at this point to predict what this ruling may do over the long term, though all the experts I called today told me it's most likely going to involve a lot of lawsuits. Let me know what you think. Email me at dan@wral.com. Also, In a few minutes, we're going to go back to this topic. We're going to look at this journey we've been on with affirmative action and pay attention to how we got here. Affirmative action is no more after today's Supreme Court ruling, but it's been a long journey to get to this point. So let's take a minute and look at how we got here. It's something that always helps me with a little bit of perspective. And we're going to start a little bit back with JFK. You see, he was the first person to use the term affirmative action in the 1960s to discuss problems with discrimination in the workforce. The idea was vague at the time, but the goal was pretty simple, calling on institutions to essentially hire more black people. Paired then with the civil rights movement, the idea really started to take shape. And by the 1970s, major colleges and universities across the country had adopted some form of affirmative action, mostly by setting aside spots that were exclusively reserved for minority applicants. But that's when Alan Bakke came along. You see, in the mid-70s, Bakke, a white man, got rejected by UC Davis Med School twice, despite having higher test scores than some of the black students who had spots reserved exclusively for them. Bakke sued, and the Supreme Court agreed with him. They decided two things. One, that racial quotas were unconstitutional and that you couldn't set aside specific spots for a specific race. And two, that despite that first point, diversity is important and race can't be ignored when striving for diversity. Justice Harry Blackmun wrote this, quote, "In order to get beyond racism, we must first take account of race. There is no other way." So schools started using race as a factor in the name of diversity on campus. Unfortunately, that word, diversity, is difficult to define. I mean, how do you know if your school is diverse enough without looking at the numbers? And how do you consider the numbers without risking a quota? It's a gray area that's led to many challenges to affirmative action over the past 60 years. And in that time, we have seen the court lean toward today's ruling. In 2003, in Grutter versus Bollinger, the court upheld affirmative action. And in that majority decision, Justice Sandra Day O'Connor held that while the use of race was acceptable in this case, quote, race-conscious admissions policies must be limited in time, and that the court expects that 25 years from now, the use of racial preferences will no longer be necessary to further the interests approved today. And while Justice Ruth Bader Ginsburg didn't agree with that timeline of 25 years, she concurred with that judgment and wrote that race-conscious programs, quote, must have a logical endpoint. And it appears that endpoint is today, 5 years short of O'Connor's prediction, and entirely up to you as whether or not it's logical. Ashley, we'll keep an eye on this, of course. People email me at dan@WRAL.com, and we'll keep the conversation going.
Dan, you know what I think is so interesting about that? Not only is the word diversity kind of difficult to define, as you were talking about, but also we keep hearing the term, admissions based on merit. That word merit, difficult to define too, and schools are really going to have to focus on, okay, well, what does merit look like for us as we try to navigate this new ruling?
We're going to see as time tells.
All right.